Thank you, Tammy. Good afternoon, everyone. We are so pleased you could join us today. As some of you know, I am the managing partner for client relations at B&B, and I have been at the firm for over 22 years as of this July. Of all the propositions on the ballot this November, the one that caused the most amount of heated debate between my family members was Prop 22. It was controversial to say the least, and there were lots of pros and cons. Today, the speakers will cover Prop 22 as it relates to the AB5 test. They will then proceed through SB 1159 and its three presumptions. They have a variety of other interesting topics to get through, but most importantly, they will cover the critical challenges and what to look for in 2021. I'm proud to have worked with these gentlemen throughout COVID, helping employers and clients understand the changes brought upon by COVID. Please allow me to introduce them again. Here are John Kamin and Zane Uribarri. Zane, do you want to introduce yourself?
Good afternoon, everyone. I'm Zane Uribarri from Bradford Barthel's Ontario office, and with John, I'll be presenting today. I'll be covering SB 1159, the new COVID presumptions, how they work, what they mean, and how to deal with some of these claims. Please feel free during the course of the presentation to ask questions. Please feel free to interrupt with questions. It's the best way to learn. But to go ahead and get us started today, we'll go ahead and hand it off to John.
Thank you, Zane, and thank you, Tammy and Tia. Good morning, everybody. Well, actually, good noon, I guess. My name is John Kamin, and I'm out of the Woodland Hills office of Bradford Barthel, where I'm partner and director of the editorial department. And that's a nice way of saying that I run the firm's blog with the help from our wonderful team. So if you forget any details from today's presentation, please note that we do have a lot of blogs up about COVID-19 and SB 1159 and a lot of the other stuff we're talking about today, and we'll continue to update that. So with that being said, feel free to check out bradfordbarthel.blogspot.com or just Google Bradford and Barthel blog or whatever topic you're looking into, and chances are we have something on the website that covers it. So with that being said, let's get started with today's presentation. And thank you, Tia. And basically because Prop 22 is the most recent thing that happened, I decided we should lead with that today, and then we'll jump into Senate Bill 1159 and the presumptions. And basically, as far as Senate Bill 1159, I know that many of you have already attended our previous presentations on that, so we tried to make that part of the presentation a little more concise, so that way we're covering it for the people who have not seen it yet. But we also are going to reduce the size of it, so those of you who have seen it before, you aren't going to have to sit through something you've seen before for a long time. So Prop 22, on Election Day, California voters approved Prop 22 with a 58% vote for yes. So what does that mean? That means that workers for cell phone services apps are not employees for work comp purposes. So Uber, Lyft, Postmates, Grubhub, those are people who are not employees thanks to Prop 22. In exchange for being independent contractors, these drivers get occupational accident insurance with up to $1 million in medical, higher wages, and there's a formula to calculate that. And basically the wages are going to definitely be higher than the minimum wage. And then there's also group health coverage worth anywhere from $184 a month if you're part-time, or $367 a month if this is your main gig. So why was Prop 22 created? Well, it was created to dispute last year's big bill, AB 5. And that was the bill approved by Governor Newsom in September 2019. That bill clarified that the California Supreme Court's ABC test applies to many types of workers, effectively replacing the right of control test, or the Borello test. And that was the test to determine if a worker was an independent contractor or an employee. So why is that important? Well, the ABC test makes it much easier for a court to determine that a worker is an employee for work comp and labor law purposes. But wait, Prop 22 only affects workers who work for big tech companies who make cell phone apps. So it doesn't affect truckers, for example. It doesn't affect people who don't work for a cell phone app company. And so if they don't work for an app company, then AB5 still controls. So examples, truckers, hairdressers, stylists, barbers, nail salon workers, those types of workers should still be wary of AB5. So AB5, as we already said, it implements the ABC test for a lot of workers. And what is that ABC test? Well, it says if a worker does not meet all three of the following conditions, then they're an employee. So for the first condition is free from the control and direction of the hiring entity. The second one is performing work that is outside the usual course of hiring entity's business. And the third one is worker is customarily engaged in an independently established trade or occupation or business. But it's that one in the middle, that's the rub. That's the one that transforms most workers into employees, because usually they're performing work that is inside the course of the hiring entity's business. Now, another thing to note about AB5 is that it created many exemptions and it's industry specific. And I could go through them all and it would probably take about an hour. So I'm not going to do that. So if there is not an exemption, the ABC test applies. Here are some examples of some of the exemptions and exceptions. Construction truck drivers got a 2-year grace period to be independent contractors, whereas regular truckers did not. Barbers, cosmetologists, manicurists, they're exempt if they set their own rates, if they're paid directly by clients, and if they do their own scheduling. Another example is salespeople. They're exempt if their salary is based upon actual sales. Commercial fishermen, they're exempt from the ABC test for everything except for unemployment insurance. Now, here's another list of exemptions and exceptions. These people are independent contractors pursuant to the language down in AB5 near the bottom. And so if you have anyone in this group, employment disputes will be subject to the Borello test. And that's the right of control test. And that's the one that we've been using in work comp for a number of years, I think dating back to 2003 or so. So that's doctors, dentists, lawyers, et cetera. And it's a long list. So you definitely want to take a look at AB5 or feel free to read our blog from last year, or feel free to contact us if you have questions about a specific line of work. So the Borello test applies to these people, right? Well, what's the Borello test? Well, it's the right of control test, and it requires the court or the judge to look at these factors. And no one factor is more important than the other factors. It's just the weight of the evidence under all of these factors. So for instance, the judge could find skill required by occupation and supplying of the tools and method of payment as the most important factors. So anyway, payment is usually an important factor when looking at right of control, and also who has the power to hire and fire. So these are the Borello test factors, and it's going to apply to, once again, this group of employees, or this group of workers, I should say, not employees. And with that being said, let me kick it over to Zane, so Zane can cover the new law, Senate Bill 1159. That's the bill with all the recent COVID presumptions. Zane?
Thanks, John, and good afternoon, everyone. We're going to go ahead and cover SB 1159, the COVID presumptions, what they mean, and a little bit about how they work. Just to let you know, in this particular area of law, I have handled over 24 litigated cases involving COVID, including death claims, determining whether or not a claim should be accepted, denied, whether or not the presumption can be rebutted. So quite a bit of time spent dealing with these particular types of cases. But let's get into the law and what the law itself is. The governor signed this law into effect on September 17th, and it was emergency legislation, so it became effective immediately, putting into place 3 different presumptions that generally will cover individuals based upon a date of injury, and then in one carve out that we'll see based upon the type of job that they have. So we'll go ahead and look into those. The 3 different presumptions presumptions are the original executive order presumption that the governor issued back on May 6th. That's now been codified, and it covers dates of injury from March 19th, 2020 through July 5th, 2020, and that's going to go ahead and cover everyone. There is then a separate carve-out presumption for police, firefighters, and then some healthcare workers for their dates of injury from July 6th of 2020 going forward to New Year's Day of 2023. And then finally, there's the other big presumption, which is known as the outbreak presumption or the everyone else presumption, covering all dates of injury from July 6, 2020 going forward, and that requires an outbreak to be found. All of these different rules, while they were in SB 1159, have now been codified into the labor code. They're in the presumption section, which is 3212, and they're there 3212, 86, 87, and 88. That'll end up being the shorthand that'll be used to refer to each section. The outbreak section is section 88, first responders is section 87, and the old executive order is codified under section 86. Before we go any further on what the presumptions are and whether or not the presumptions apply, it's important to remember that just because a presumption doesn't apply to an individual, it does not prevent them from going ahead and filing a claim for COVID-19 and for an injury related to work and proving that claim by a preponderance of the evidence. That is still something that can be done. Normal rules and procedures would then apply in that particular case. If you received a claim form from someone and they're going to pursue the case not under the presumption statutes, but just as a regular injury, you still have 90 days to do some discovery, make a determination on compensability. So the regular rules would apply. The new law, SB 1159, does specifically allow individuals to go ahead and bring their case and prove their injury by preponderance of the evidence if they can't meet all of the requirements of the presumptions. And let's go ahead and look at what those presumptions are and what is required. So the first one is the executive order presumption, and it covers the initial, these initial dates from March 19th through July 5th. That was the time period that was covered by the initial executive order, and that's the time period covered by the new subsection 86. In order for this presumption to apply, and the presumption is that someone's positive COVID-19 test, their injury for COVID-19, the presumption is that this is work related. So in order for that presumption to apply, an individual has to have a positive test or a diagnosis of COVID-19 within 14 days of performing work for the employer, the employer's direction at the employer's place of business. So that is initially what is required in order to have the presumption apply for this particular date range of injuries. If there is a diagnosis of COVID-19, that has to be confirmed with a test, and SB 1159 expanded the types of tests that can be used and allows you to use an antibody test and not a positive COVID test. So you need not have a positive COVID test for these dates of injury in order to have a presumed compensable claim. You can now use the antibody test itself. When you are looking at someone working at the employer's place of employment or at the employer's direction, what you're essentially looking for are individuals that are going out into the world and doing work as they normally would, not individuals that are solely working from home. The purpose of this is to exclude individuals that are just working from home that may contract COVID. They would not have a compensable claim because you must test positive within 14 days of performing work for the employer at their place of business or at their direction. And when you think about their direction, think about truck drivers. They're very rarely at a place that is owned by the employer. They're usually delivering product to third-party vendors or out on the road. The executive order applies to everyone, and the new subsection 86 of SB 1159, that applies to everyone. Many people believe that it only applied to essential workers or people that were considered critical workers, but it applies to everyone. So anyone who was working between March 19th and July 5th, whether or not they should have been working or not. So the positive test that you have to have within 14 days of performing work was something that was that critical first step. It was a positive test, and back then for the executive order, you could also have a diagnosis. And that diagnosis had to be made by a California licensed physician And under the new law, the diagnosis can be made by a good number of different healthcare providers, an MD, a DO, a nurse practitioner. They can make that diagnosis and then confirm it with a positive test of some kind within 30 days. So it's much easier to have a presumed compensable COVID case now under SB 1159 than it was under the executive order. Now you could have a nurse practitioner make a diagnosis of COVID-19 and confirm it with an antibody test, whereas you would not have been able to do that under the old executive order. So once a case has been presumed compensable, what do we do next? An individual that believes that their case is work-related will then file a claim form, and you have 30 days to either accept or deny the claim. 30 days to do that discovery, 30 days to try to gather additional information, usually from the employer directly, and try to make a determination regarding whether or not all of the different prongs of the presumption have been met. There was a test or a diagnosis, the individual's working within 14 days, get some employer records, and maybe perhaps conduct some of your own discovery before that 30 days runs. But if the claim is not denied within 30 days, it is presumed compensable. That presumption can then be rebutted by evidence discovered after the 30 days. So it is important to always continue discovery even after you have made that determination that a claim should either be accepted or denied. Continue doing discovery, because you'd be surprised at the additional information that you will find as a case goes on that may allow you to rebut the presumption that it is compensable. TTD, really quick, was very different under the executive order in terms of timing and what was required, and that's been codified now by SB 1159. So you have to have a doctor's certification within the first 15 days of the initial diagnosis, and this is for these dates of injury, March 19th through July 5th. So when you get someone that has brought forward a claim and they bring forward a claim date of April 15th and they filed it now and they want retro TD, these are the requirements that they had to go through. They had to have these certifications every 15 days for the first 45 days in order to receive TTD benefits. The long and short is a positive test and then going home and never going to the doctor would not be enough in order to collect TTD benefits. There would have to be something more than just a positive test as the law is currently written. We'll see whether or not that's going to be the case as case law is made and as regulations come down. But right now you had to have the positive test and you have to have a doctor's certification. If you had a date of injury and you were asserting TTD for March and April, anytime before the governor's executive order of May 6th, then you had to get that retro TTD certification by May 21st. It was a hard and fast rule under the executive order, and it continues to be the same rule under SB 1159. So that's the old executive order test. That was for those particular dates of injury. And then moving beyond that to dates of injury of July 6th going forward, those have been divided into essentially two sections. We have the police, fire, and healthcare presumption. And that's going to be different than the outbreak presumption. But the police, fire, and healthcare presumption is essentially asking the same questions. Did you test positive within 14 days of performing work for the employer at the place of employment or at their direction? So it is essentially the same type of test that you are looking at in order to determine whether or not the presumption applies. It's important to remember that for this particular presumption, for the healthcare worker presumption, the first responder presumption, the individual has to test positive for COVID-19. A diagnosis followed by an antibody test is not allowed here. And it's very important when looking at this section, and this is Labor Code 3212.87 for the police, the firefighters, and the healthcare workers. It's very important to look under subsection A and see whether or not the particular worker, employee, or applicant who has filed a claim falls into one of the categories that's covered. So this particular presumption applies to literally all firefighters in California. It's firefighters, forestry workers, and even the NASA firefighters are covered by this presumption. Anyone in California that is labeled a peace officer, and that can be quite broad. Fire investigators are also considered to be police officers. other types of law enforcement, and then some specific healthcare workers are also going to be covered. So you do want to make sure that the particular employee is covered by this presumption before assuming that this is the presumption that will cover them. So we'll look into a little bit more about what this is. What does it mean to be a healthcare worker? If you provide direct patient care, or if you are working at a healthcare facility, that is one particular way that we're going to know whether or not you're a healthcare worker. John, do we have a question?
Oh yeah, we actually had a question that pertains to this slide. And the question from Sharon was, are all healthcare workers covered, or is it only workers in a healthcare facility? And as you see here, Sharon, it is employees who provide direct patient care. SB 1159 does list RNs, EMTs, paramedics specifically. And then also, as you see down there, a employee who provides direct patient care for a home health facility. And also, Zane and I were actually talking about this the other day. This SB 1159, this section, so the first responder section, talks about the health and safety code too, section 1250. And it mentions about 5 subsections in there. And we looked at all 5 of the subsections. And all of those are overnight facilities, so inpatient, like hospitals, psych hospitals, skilled nursing facilities, continuous nursing facilities. And so basically it's important to differentiate those from, let's say, a chiropractor's office. So a chiropractor's office, while we'd all think of that as a healthcare facility, it doesn't meet any of those subsections under the health and safety code, nor is the chiropractor mentioned in subsection 87. So I just want to provide a little more clarification to answer Sharon's question about which healthcare workers are covered.
Looks like we're getting a few other questions in there. And yet to go off of the healthcare facility, it is something that's very important to look at, see if the employer qualifies as a healthcare facility. There is some question about whether or not urgent care facilities are actually going to qualify as a healthcare facility since people do not stay there overnight. So something to consider is what kind of healthcare facility it actually is and what they do, and not just the individuals that are working there, although some healthcare workers do have their own individual presumptions, such as registered nurses. John, was there another question?
And yeah, one of our audience members noted that a authorized registered nurse is not the same as what we think of as a traditional RN. An authorized registered nurse apparently provides care in an ambulance, whereas an RN, as we all know, is more in the hospital usually. And then we also had a question about custodial employees, which I think you're going to address in the next slide, right?
I believe that we will hit that in the next slide. Oh no, it's you want to touch on that real quick though, custodial.
Sure.
Go ahead.
Yeah, so basically the statute also does mention custodial employees who may have direct contact with patients who have COVID. And so a good example of that is a laundry worker, for example, who works at a hospital and goes into the patient's rooms. So that laundry worker could foreseeably go into a COVID patient's room, collect their laundry, get within 6 feet of the patient, and then go take that laundry to the laundromat and clean it. Well, that person could be covered under subsection 8.7. On the other hand, employers can rebut that person's presumption by showing that, hey, that custodial employee did not have contact with any patients who had COVID in the last 14 days before their last day of work. And so how would you establish that? Well, supervisor testimony or managerial testimony is a good way to help show that.
And when it comes to this particular section of SB 1159, we still have the same 30-day time frame from the time the claim form is submitted and received by the employer. You have 30 days in order to make your decision on compensability. Otherwise, it will be a presumed compensable case. You can use after the fact evidence, so evidence discovered after the compensability decision has been made. You can use that evidence to then rebut the presumption, but you're going to have a presumed compensable case unless you go ahead and get that denial issued.
And Zane, there was one last question. What if the employer reported that an employee passed away and they got a note from the doctor saying that the patient was positive for COVID when they passed away? Is that going to be automatically presumed compensable under any of these presumptions? And I think the short answer is no, right? It's not going to be automatically presumed compensable.
Right. There still has to be an assertion that the individual's injury was work-related. They still have to make that, and usually that is made by the filing of the claim form, and you're going to find that in death cases, it's going to be the dependents that are going to go ahead and file the claim form. And in some cases, they don't. On many non-litigated cases that I have seen and assisted with, individuals that have passed away where their source of exposure was clearly outside of work, say there were other family members in the house who were ill first, those individuals are going to have a case that's going to be that has good grounds to be rebutted. Their presumption would be rebuttable, and they don't even file the claim form or assert that this is in fact a work-related injury at the beginning. So after the first responders section, they have that carve out for those very specific workers. And I do urge you to check the statute itself and make sure that the individuals that are listed in the statute are actually the job titles that are being held by the applicants. As we can see, there are many, many different types of healthcare workers. So you do want to check on that. But the last presumption is the everyone else presumption. This is the presumption that's going to apply to the lion's share of workers for dates of injury of July 6, 2020 going forward to New Year's Day of 2023. This is the presumption that has the outbreak requirement. There's a little bit of extra time, presumably because you have to do that outbreak calculation and maybe even gather additional information. So there is a 45-day decision time frame. Again, it's triggered by the filing of that claim form. Again, if you do have a case that is accepted because all of the elements of the presumption have been met, it can still be rebutted with new evidence that is discovered after that 45-day time frame has run. So what are the requirements for the everyone else presumption or the outbreak presumption? You have to test positive within 14 days of performing work for the employer at the employer's place of business and at their direction. We keep saying this over and over again, essentially excluding individuals that are solely working from home. Keep a close eye on individuals that work part of the time from home, and then part of the time will go in to their employer's place of business. We're seeing more workers that are maybe going in once a week, maybe going in to obtain new documents or new items that are needed to do their job at home, and then doing the majority of their work from home. But if they have been to work and if they have performed work for the employer within 14 days of that positive test, then they're going to meet that particular prong of this presumption. And this presumption also requires that there be an outbreak. So there has to be a legally defined outbreak that has occurred at the specific place of employment where an individual works within 14 days of the test. The outbreak, quickly, we'll look at that. It's defined by the 4 and 4 rule. You're going to look at the number of people that work at that particular place of employment and see if there are under 100 or if there are 100 or more people working at that location. If there's under 100, there have to be 4 positive COVID tests within a 14-day period at that location in order for there to be an outbreak. And if there's 100 or more employees, then 4% of the workforce has to test positive, again, within a 14-day period. So that's what you're looking at. And you're looking at a 14-day period that's not just before the date of the test or after the date of the test. It's at any time around it. So it is a bit of a dynamic calculation and something that you have to look at in order to determine whether or not an outbreak has occurred. Employers will also at times at the same location have multiple outbreaks based upon how many employees actually test positive. An important thing to remember here is the date of injury. When you have a claim and a claim is being set up, the date of injury is now defined by statute as the last day worked. That is different than the date of the positive test. The date of the positive test is the date that the individual actually tested for COVID-19. And the date of injury is almost never the date of the positive test, the last day worked and the date of the test, it's usually off by at least several days. So you do have to keep track of that. For determining an outbreak, it's the date of the test. For determining which law applies, you're looking at the date of injury. And when you're doing discovery to try to do contact tracing, you look at the date of the individual's first symptoms and go backwards from there to try to figure out were there other sources of exposure other than just being at work. But when you're trying to determine that outbreak, look at the date of the test. The example we have here at the bottom is if your test date is on 8/31, you're going to have to look at the 14 days before. So you're going to have about August 17th up to the date of the positive test, and then also the 14 days after, but also any combination of a 14-day window that is in between. It could be August 28th going up to September 11th. That's a 14-day window, and you may find that you have an outbreak there, even though you didn't have an outbreak for the 14 days before or the 14 days after. So it is basically a window that you're going around with the date of the positive test in the middle. There are commonly questions on that, and happy to answer any that you might have. If there is no outbreak, then there is no presumption. The presumption doesn't apply. So you will not have a presumed compensable case like we did under the executive order if there is no outbreak. And determining the outbreak is going to be the job of the claims examiner. They're going to get information from the employer. Later on, that information is going to be obtainable by applicant's counsel since it is trying to prove whether or not an individual is entitled to benefits. It would be discoverable information. Applicant's attorney may disagree. It may go to trial. Ultimately, a judge may determine whether or not there was an outbreak at a specific place of employment. But initially, that is being done by the claims examiner. And that the information that is being used in order to make that determination is information that is provided by the employers, who are now required to report positive tests without identifying information, including the date of the test and the location where the employee worked. If they worked at more than one location, each location must be reported, and that's a positive test for each different location. And then they also finally have to report the highest number of employees that have worked there in the last 45 days. This is so you can determine if there are less than 100 workers at a place of employment or 100 and more, so you know which of the 4 and 4 rules to use for positive tests, or whether or not it has to be 4% of all of the individuals that were working at that location. Very quickly, there is a website that's here at the bottom of this slide. It's for the FDA on approved tests. Make sure that when you get a positive test, it is an FDA approved test. Some of the mouth swab tests are not FDA approved. And so that is something to definitely look for. Also, make sure that it is a test for COVID-19. There are some tests that are floating around are for other coronaviruses, and those can't be used. And also do make sure that the person's name is on the test results that you get. I am quite shocked at the number of times that I have seen tests being handed in by employees that don't have any identifying information on them, that maybe even turn out later on to not have been their test results. So that is something else to watch for. Death without dependents has been waived, and this is for all dates of injury and for all for the first responders under the outbreak presumption and under the original executive order presumption. If an individual does not have any dependents, then there is no requirement that money be paid to the state. On death cases, though, do make sure that you are aware of all the dependents and who is entitled to be paid, and make sure that you do your usual due diligence in those cases. John, do we have another question?
Yeah, we have a few questions about some of the stuff you've been talking about. So the first one is, what if they were exposed while on their break? And unfortunately, they didn't give us a last day of work, which would tell us which presumption might apply. But Zane, I believe that what we would do is we would first determine which presumption would apply by last day of work or date of injury. And then we would determine whether a presumption applies. And then if no presumption applies, then you treat it like a regular claim and see if their work put them at greater risk, or see if they can prove beyond a preponderance of the evidence that their work put them at greater risk of catching COVID. Is that something you would agree with?
Yeah, I think so. And you're gonna kind of treat whether or not it's work related in the same way that you would look at any other kind of case where an individual was injured. And one thing you do want to look at when you're investigating claims is look and see if individuals carpool to work together, which is not required by employers, which is something individuals choose to do on their own and could serve as a source of non-industrial exposure to COVID-19, especially if both individuals end up testing positive. So that is something else to do, but the usual rules in terms of whether or not something is industrial or not would apply. It looks like we have quite a few other questions here.
Yeah, and going back to the break question, one of the other, so let's say no presumptions apply with the person who catches it while they're on their break. You still have to look at the personal comfort doctrine. And what that says is that if the employee takes a quick bathroom break and let's say slips and falls and hurts their knee, then that's still compensable because the law basically says that a quick trip to the bathroom or to grab a cup of coffee is still in the course and scope of employment. Now, if they substantially deviate from their work during their break, like let's say they drive to the DMV to go get their driver's license updated, and then they rush back to work and they got exposed at the DMV, then yeah, that's probably not going to be covered if no presumption applies. So I just wanted to mention the personal comfort doctrine. And then we also had oh, go ahead, Zane.
No, that is very good. It would also be very, very difficult, I think, to show that an individual became ill at a very particular time, like on a break, unless there were some very specific facts that showed that that's when the exposure took place.
Yeah, and it looks like we're getting additional facts here. The applicant was on her break visiting a coworker who was in the ER, and the coworker had COVID at the time and didn't know that she had it. So it sounds like this would be a potential claim under subsection 8.7 because we're talking about healthcare workers now. And it sounds like that's probably not a substantial deviation from employment. So A, you have to worry about the presumption applying under the healthcare and also depending on what type of worker she is. But it sounds like even if it is a normal claim, that's not a significant deviation from the course and scope of employment. We also had another question about if a resident, let's say you have an apartment complex and a manager at the apartment complex, of course, goes to different people's apartments and they're exposed to COVID, is that manager still protected? And I think under these presumptions, we don't see any exemption or exclusion of managers, do we, Zane?
No, we don't see anything like that. But also, the question may be asking, is the fact that the manager is coming into contact with residents, is that going to be something that has to be considered? Do we have to look at the number of people that live there and how many of them are ill when kind of making an outbreak determination? And the answer is no. And it is a great gigantic gap in this particular new law that we don't look at the general public and who the general public may be exposing to COVID-19, and that you only look at other employees. So you don't look at third-party vendors that come into a workplace when you are determining whether or not there is an outbreak for a truck driver that is delivering at a location. That truck driver is going to be the only individual from the employer going to that particular location. You're only ever going to have one positive case at that location. There would never be an outbreak, even if there were dozens of other individuals for a different employer at that location that had tested positive. And then for retail workers, they are only looking at other employees and whether or not there are enough other employees that have tested positive, and they're not considering the general public that someone like a cashier would have much more interaction with than perhaps their other coworkers.
And Zane, two more quick ones, and then we'll wrap up the COVID questions and try and get them more at the end. One is a common question, which we've seen quite a lot. When do you recommend providing the DWC-1 form to workers who have COVID?
And that's as soon as they have made a claim that this is going to be work related. So we still have to go ahead and follow the case law that exists, especially the Honeywell case. There's nothing here that overturns that in any way. Usually, we've advised employers during the course of their investigation to ask individuals, "Oh, wow, how did you get it?" Because they oftentimes, if they don't say that they got it at work, they will tell you exactly where they got it. Individuals, we are finding, know generally how they were infected because they know that they were around someone else who was infected, or they had an infected family member. I have one case where an individual admitted to a doctor that her son was sick first because her son's babysitter was sick first. And so that's where the source of exposure comes from. But it's when they make that claim that this is work related, that they say, "I think I got this at work. I'm around other individuals that are at work that are sick, and I think I got it there." That's when you would need to be providing the claim form.
Okay, and one last question. Let's say that the employee was solely working from home, and they tested, and then they test positive for COVID. Does the employer need to report that to the TPA?
Oh, that is a good question, because they're not going to qualify for the presumption because they were solely working from home. But unfortunately, the reporting requirements that are in 321288 subsection I, when you go down and you read those, there's no requirement that the individual who has COVID-19, there's no requirement that it be industrial COVID-19. You could have 4 or 5 individuals that test positive for COVID-19, and all of them admit that they got it over Thanksgiving. They were exposed to a family member that was sick, but those cases still have to be reported, even if the employer knows that the cases are non-industrial, even if they can't meet a presumption, even if there's some piece of the presumption that's going to be missing. So when it comes to reporting the claims should be reported under subsection I, because subsection J has got some pretty sharp teeth when it comes to the penalties. So it's better to be reporting the claims, even if they can't be industrial claims, rather than not reporting the claims and later on having a judge figure out, you should have been reporting those claims all at this time.
And just one cherry on the top of that answer, when you are reporting that claim, we do recommend including the employee's address as the employment site, unless they'd be able to identify the employee personally. And the reason why is that the employer reporting section of the outbreak statute does call for the employer to mention the address of that specific location. And Zane, how about if we how about if you cover the next few slides, and I'll try and answer some of these questions via typing. And if
Sure.
we can't get them now, we can hit them at the end or answer after the presentation.
Sure. So real quick here on the next couple of slides, looking at investigation and what is needed when you're looking at a case for the first time. As soon as that claim form's been turned into the employer, and now you've got either 30 or 45 days, what kind of discovery should you be doing? And from the cases that I've handled, the information that you are going to get that's going to be the most helpful is going to come from a couple of sources. First, coworkers, what they have said to supervisors and what they will say in terms of how someone was infected or other activities that someone may have been engaged in. People are usually talking a little bit more with their coworkers. That's a good source of information. Social media has proven to be invaluable in terms of doing contact tracing, figuring out where someone was at a particular time. Not only will people tag where they have been, they will post a picture, and they'll post a picture of them at a barbecue with a lot of other people. And then they may tell you in a deposition that they haven't been anywhere and haven't done anything. But if you check that social media first, you may find that to be a wealth of information as to what an individual is doing. Check it quickly though, and save the information. I have had a case where an individual deleted their Instagram account when I asked them about it in a deposition. Fortunately, I'd already saved the information, but once they realized that it was there, they went ahead and took it down. So part of the investigation that you want to do is build a timeline, figure out when the symptoms first started, and go back about 2 weeks, because that's the infection period, and try to figure out, were there other sources of infection other than work. Also ask the employer about the protective measures that they use, such as social distancing and masks and any kind of cleaning schedule that they use. Did they require the employees to be following these procedures? How strict were they about it? It's important because Subsection 88 actually allows you to rebut the presumption a little bit easier by bringing in this information in terms of the safety measures that were being used by an employer, and then counterbalancing that with the risk of getting COVID-19 on a non-industrial basis for that particular individual. If someone else was sick at that individual's house where there's no social distancing, no masks, common rooms being used all of the time without being cleaned, and then you contrast that with the employer who has all of these protective measures in place, it makes it much more likely that the source of the infection came from home rather than coming from the applicant's place of employment. With that, we're going to start getting into some of the TTD benefits and other benefits that are available specifically under some of the new legislation. And I'm going to kick it back over to John.
So with temporary disability and Labor Code 4850 benefits, so wage replacement benefits, SB 1159 mandates that COVID-related sick leave must be exhausted before those benefits can begin. And so the federal government, they mandated that COVID sick leave in a law known as the FFCRA in March 2020, that employers pay COVID sick leave of up to 80 hours. So that'd be 40 hours a week, so 2 weeks, 80 hours. And that would be at the full rate of pay. Now, the FFCRA exempted employers with more than 500 employees. It exempted certain types of healthcare workers. And it also said that employers with less than 50 employees can be exempt. So when we're talking about sick leave, it's also important to note California's Assembly Bill 1867. Because as we just noted, the federal legislation had a lot of exemptions and exceptions. So the California bill, which the governor signed into law in September, that one plugs almost all of those exceptions and exemptions. Long story short, what you need to know is that if you have a full-time employee, then the employer should pay 80 hours of sick leave at regular pay before temporary disability begins. If they're a part-time employee, it's proportional sick leave. So if they work 25 hours a week in the 2 weeks before they go out, then the employer should pay 50 hours of sick leave at the regular rate of pay. And this bill took effect immediately. And what's interesting about this is that because this bill was designed to plug the gaps of the federal legislation, it also lives or dies with the federal FFCRA. As you know, there's some turmoil, to put it lightly, at the federal government level, and that FFCRA expires at the end of this year. So when that expires, this Assembly Bill 1867 could also expire. That being said, many of us are hoping, and it does look like there's grounds for some optimism, for a deal to be reached and for that FFCRA to be extended well into 2021 and beyond that. So if that is, then this sick leave bill in California will also be extended. AB 1867 also has some other notes you want to definitely take note of. For some of the healthcare employees, for example, this highest rate of pay element can come into play. So the sick leave is capped at $511 a day, up to a max of $5,110 total for 80 hours. AB 1867 doesn't provide sick leave for workers who are caring for a quarantined family member or caring for a child whose school or childcare closed. Another interesting side note, it mandates that food sector workers must wash their hands every 30 minutes. Assembly Bill 685 is another one I want to tell you about. This one takes effect on January 1st of the upcoming year, and it requires that employers give written notice to all employees and subcontractor employees who worked at the same work site as an infected person within the infectious period. So I asked the state, hey, how do you define infectious period? And they promptly ignored me. But I did look at the CDC guidelines, and they have been defining infectious period as 2 to 14 days, which I'm sure you've also seen in the media that we all watch. So AB 685 also requires employers to notify all employees about COVID-19 benefits under state, federal, local laws. And guess what? That includes workers' compensation. Employers want to be careful not to name the infected person to coworkers, as that could violate their privacy rights. Now there's also more under AB 685. It requires the employer to notify employees about the employer's disinfection and safety plan, which is supposed to conform to CDC guidelines. And written notice also needs to contain the same elements as this Cal OSHA Form 300. 685 also has outbreak reporting, and they use a different definition of outbreak reporting. So in short, they require the employer to tell the State Department of Health if they've had an outbreak. And the definition under 685 of an outbreak is 3 or more lab confirmed tests of COVID-19 who live in different households within a 2-week period. So if it's a pair of relatives and then a third person and the relatives live in the same household, then maybe you don't meet the 3 threshold. Anyway, I just wanted to let you know that is a new element that will take effect in 2021. Another bill that was passed this year makes Zoom depositions easier in the time of the pandemic. And the reason why this came up is some attorneys were objecting to Zoom depos purely as a delay or obstruction tactic. Well, the California Judicial Council adopted this emergency rule that allows court reporters to participate in depots remotely. And so this eliminated the need for the other party's consent to do a remote deposition. Well, SB 1146 codified this, and it plugged it into the Code of Civil Procedure, thus making Zoom depositions easier to schedule. So let's do a brief look ahead before we wrap up the end of the presentation here. And so generally speaking, we can expect across the board more COVID legislation and regulations at the state and federal level. So looking at regs from the state level, what could we see? We could see rules and regs from the DWC to clarify some oddities and inconsistencies in Senate Bill 1159. And they could clarify some of the vagaries of the statute. And one question we've had come up, should cases before 7/6/20 be considered for an outbreak? I can think of one situation where I think there were 3 positive tests between July 1st and July 5th, and the 4th one was on July 7th. So that is an interesting timeline question, and the answer isn't exactly clear when you read the bill. Some other stuff we can expect from the state are more fee schedule updates for COVID drugs, more rules and regs impacting the practice of law and court filings at the WCAB. And you also want to buy this year's labor code book, because that's going to have all the rules and regs with the correct numbers. For those of you who are attorneys or like reading the labor code and the rules and regs, you will know that the 2020 book did not have the correct numbers, and you had to look them up online if you wanted to look up the correct rules and regulations. Here's what we can also expect in California in 2021. Well, we have the vaccines coming around the corner, which I'm sure you've heard about. And vaccines, once widely available, could be required for kids to go back to school. I personally wonder why not require vaccines for the presumption to apply to. And does it make sense that you would have someone ignoring or not taking a vaccine and they don't have a valid medical reason to skip the vaccine, they just don't want to take it, but then they're going to, go and try and get the presumption. That doesn't seem to make much sense, especially when kids are going to be required to have the vaccine to go back to school possibly. Also expect from California more industry-specific worker protections as it pertains to COVID. And also expect some tweaks to how EDD administers benefits. You may want to note that a week or 2 ago, their director just resigned in the wake of the unemployment benefits mess. Also keep in mind that Governor Newsom has mentioned that he plans to continue to meet with labor to potentially challenge Prop 22. Then we also don't want to forget about what's happening at the federal level. The Biden administration reportedly plans on creating federal employer guidelines for COVID. That could have an impact on what employers have to tell their employees, because if Biden changes the CDC guidelines, then that changes what employers tell their employees under AB 685. Also expect the feds to take a look at extending COVID benefit and unemployment benefit programs. As far as vaccines are concerned, it's important to remember that there has to be a deployment plan for the vaccines. And it could be difficult for various local governments to implement that. But definitely expect your highest risk people to be put first in line for the first vaccines, then second highest risk, and so on. The federal government may also subsidize the cost of the vaccine as a public health measure. And also, we could see further healthcare worker and first responder protections from the federal government. Now, we do also have a few rules and regs. And let me just take a look at the questions here. Okay, so we are kind of running out of time. I'll run until about 1 and then maybe hit up a few more questions. I did want to touch on some of the rules and regulations which are going on. They're still in pending mode right now. And the DWC has plugged ahead with work on the copy service fee proposal and also the med legal fee proposal. And so the copy service fee proposal forum comments were posted in October 2020. And the med legal fee proposal has a hearing set for December 14th. And those comments were posted in midsummer. So the copy service fee proposal would increase the standard reimbursement rate $30 up to $210 for 500 pages or less. It would also require the statement under penalty of perjury that the party who requested the records actually requested them, and that the request was in good faith, it wasn't duplicative. Essentially, it was done in good faith. So why ask for a statement under penalty of perjury in the first place? Well, the reason why is that long-running practices by bad actors have automatically issued subpoenas without request from AAs. And the defense bar has seen this as an attempt to rack up billing. And we have a hot link in your presentation to the WorkComp Central, which talks about the statement under penalty of perjury. Labor has criticized that statement as not being necessary and creates additional burden, whereas the defense bar has complained that it has no teeth. It can be easily manipulated, and it doesn't have any teeth to make it enforceable. The med legal fee proposal would increase evaluation costs to $2,015, reavels to the numbers mentioned here. And with that being said, we're coming up on 1 p.m. So Zane, are there any other questions which caught your eye?
I'm going through typing as fast as my keyboard is smoking. I'm trying to get through so many of them. John, one interesting one here. If employer offers testing on site, but you're not required to do the testing, but you are required to have a negative test before you come back to work, and the individual is injured while the test is conducted, would that be a work-related injury?
Well, that's an interesting question, because if the employer asked them to get the test, and they said, we set this up for you, then arguably that's for the benefit of the employer. It's kind of like to me, it's comparable to the situation where if someone is injured while treating for a work-related injury. So if you view it through that lens, then it is possibly compensable. On the other hand, if they deviated from that, or they went to a different location or didn't go to the location that the employer asked for, then maybe not, maybe it isn't. Frankly, it doesn't sound like that would have much indemnity to it.
And it wouldn't be a COVID-related injury either. It would be essentially, it's a nasal injury, I guess.
Correct. And I did see one question earlier, which I don't think we addressed, and that was asking about what kind of PD and future medical care we might be looking at under any of these claims, under any of these presumptions. And I think you have to look at it from a respiratory viewpoint. So how do those lung function tests come back from a pulmonary QME? And it is important to know that in some of these less severe cases, some people can completely recover from pneumonia if the drugs work. So it's important to pay attention to those tests. And also those pulmonary QMEs, they're also trained in cardiology as well. So they are literally prepared and trained on how to treat heart issues and identify those and recognize those.
If I can add really quickly, I know there were quite a few questions today. We had over 400 people in the audience. So Don't worry, we will get those answers out to all of you. We do keep track of those questions, so rest assured we will be answering those questions shortly. So we thank you all for joining us, and we appreciate the time that you spend with us.
Thank you very much.
Thank you, everyone.
Have a good afternoon. Take care.